Always show up.
Hey, good evening. Thanks for being here this evening for this discussion. For those who don't know me, my name is Glenn Smith. I'm the finance director here in Laconia, and I'm standing in for the city manager, Kirk Biotti, who was called away to another engagement this evening, so he sends his apologies for not being here. So thank you all for being here, and it's my pleasure to introduce Steve Buckley, who is counsel who represents us and advises us through NHMA. And he's here to talk to us, of course, about the right to know law, specifically how it relates to public meetings and what can and can't and shouldn't be done, and should be done, how things should run to make the meeting keep the meeting legal and run the way it should. Before I hand it over to Steve, just want to ask, did everybody pick up a copy of his presentation up here?
No.
If not,
Thank you. Anyone else?
so thank you for that. As I said, we are recording this session, so if anybody wants to see it again, or if any of their compatriots aren't here this evening and want to view it at another time, Nancy will be sending out a note to that effect tomorrow. So that said, I'll hand it over to Steve, and take it away, it's all yours.
Thank you. I am your legal services counsel, so thank you to the City of Laconia for being a member of NHMA, the National Municipal Association, that allows us to do this, among other things, on your behalf, both at the legislature and also training local officials on important laws such as the right to know law. So this presentation is, again, focused on the right to know law, RSA 91-A, as applied to public meetings and non-public sessions. We had a previous presentation this afternoon at 1:30 on governmental records, remedies, and retention of records. This is a little bit more focused on some of the things that you need to know as a member of a public body and the ways and means of making sure you stay in compliance with the right to know law. I do want to mention that we have a publication, New Hampshire's Right to Know Law. It was updated in 2021, and we're actually doing a supplement in the very near future. It has a number of elements that you might find very helpful in understanding how to navigate the ways and means of the right to know law, including a glossary. Can't quite read my own handwriting here. Remote participation checklist, if you're having people participate remotely, how to have a checklist to deal with that. A non-public session checklist, so if you're going to go into non-public session, here's a checklist you can follow to comply with the law. We have guidance for law enforcement, because there's a lot of regulations and matters involving public records for law enforcement that we particularly need to help police departments comply with. We have a copy of both statutes. The statutes that are, I think, of concern is 91-A, plus there's a separate statute on retention of governmental records, RSA 33-A, which we go through and provide at length in the publication. There's a table of cases and a table of statutes, so would also recommend that as a resource that you can obtain from NHMA, and it's a downloadable document, so you can use it through your PDF viewer and access things using keyword searching. So today's presentation, as I've already indicated, is going to be addressed to governmental meetings and non-public sessions. So let's start with governmental meetings. And what I'm going to address specifically with regards to governmental meetings is what is a meeting, what is not a meeting, what we sometimes refer to as a non-meeting, which is not a great definition, but it's one we have to employ given the language of the right to know law. What are the requirements for holding a proper public meeting, and how to hold meetings virtually. To some degree, you have some ability to have virtual attendance at your meetings. We really don't currently have the ability to do all virtual meetings, which we temporarily had as an ability to do so based upon an executive order issued by Governor Sununu during the time of the pandemic. But there are some elements of virtuality, if I can use that term, where you can have some members, less than a quorum, of a public body participate in a meeting virtually using Zoom. And you can also, by the way, just as emphasize, you know, we all learned how to use Zoom and use virtual public participation in your public meetings. And public bodies are allowed to continue to have the public attend your meetings virtually. That's certainly permissible. You might want to set up rules about if people want to participate, they've got to do so by identifying who they are, and they can't do it anonymously, and other such rules. But allowing the public to see and hear what's going on at public meetings virtually from home on Zoom or other public access methodologies certainly is, continues to be a good idea. So I always feel it's important to start with this element of understanding the right to know law, that it comes from the New Hampshire Constitution. So we have Article 8, Part 1 of the New Hampshire Constitution has a number of important elements which were later incorporated into the statute that became the right to know law. So government has to be open, accessible, accountable, and responsive. And the public's right of access to governmental proceedings cannot be unreasonably restricted. Government has to be therefore to the ends of allowing the public to have access. And these are just paraphrasing various elements of the New Hampshire Constitution. And to understand how that affects the ways and means of local government is to recognize that whenever there's a constitutionally based right, such as we're all familiar with the rigorous enforcement of the First Amendment and other elements of the national Constitution, the local New Hampshire Constitution has the same degree of jealous enforcement by the judiciary. So the judiciary is very carefully in making sure that there's adherence to these constitutional principles. So keeping that in mind may, as a result, make it easier to understand why judges spend so much time and attention to making sure that, you know, local government turns square corners with regards to the right to know law. And before I go any further, I do want to recommend, for those of you in the land use realm, some of you may be familiar with this book, which is the brand new one put out by the Office of Planning and Development, which is a compendium of land use statutes. But the other wonderful thing about this book, which you can obtain from your Regional Planning Commission, at a very nominal price, I get them for $5 myself, because they're much more expensive if you buy them on the open market. The chapter on the right to know law also has all the really significant case law annotations. So if you had a specific inquiry about a right to know subject under, say, non-public sessions, all of the significant annotations are in this book. So it's a really handy reference guide. And I'm on a zoning board of adjustment myself. Whenever I go to a public meeting, this is always with me. But to continue on this importance of the New Hampshire Constitution, these concepts in the New Hampshire Constitution were then incorporated into the purpose section of the statute of 91-A. So of the three most important elements of the right to know law, we'll be dealing with at least the main one here is access to public meetings. That the conduct of business is essential, openness is essential in the conduct of public business, and the chapter, the statute as adopted, is intended to ensure the greatest public access to the actions, discussions, and records of public bodies. And that's sometimes the area where public bodies get a little bit fuzzy around the edges of what are our duties to comply. Because most of you would agree, if you're a member of a public body, whether it's the trustees of trust funds, or the supervisor of the checklist, or the zoning board of adjustment, or the conservation commission, if you're going to make a decision that affects people, you have to do that at a public meeting with notice to the public that they can attend and listen to what you're going on. But sometimes it gets a little fuzzier. Well, what if we're just sitting around having discussions on something related to the right, some part of our public business? And so what's important, and I emphasize, is that the purpose section of the right to know statute says that the public has a right to not only access meetings when you're making decisions, but also when you're discussing public business. And certainly allowing the public to have access to public records is a very important part of that principle set forth in the Constitution and now, as I've described, in the right to know law. So what's a public meeting? So a public meeting is pretty easily defined in the statute. Anytime a quorum of a public body convenes for the purposes of being able to communicate with each other contemporaneously, to discuss or act upon something over which the public body has supervision, control, jurisdiction, or advisory power, that's a public meeting. So in most instances when you're trying to define, by the way, as I go through this presentation, if you have questions, please raise your hand and answer those questions. The starting point is it's a quorum. How do you decide what is the quorum of your public body? In most instances, either by charter, the city charter of Laconia, or by statute, the membership of a public body is defined, that the planning board will have 7 members, or the trustees of trust funds have 3 members, or whatever public body. It's defined either in your charter or by statute. What is the membership of a particular public body? Once you know that, it's very easy to determine what's a quorum. A quorum of that particular body, if it's the planning board of 7 members, the quorum is always going to be 4 members, because that's the majority. So that's the starting point. Whenever you have a quorum of a public body, and they convene so that they can contemporaneously communicate with each other, now you have a public meeting. And it also has to include something over which that public body has jurisdiction control or advisory power. And by the way, the convening can take place in a number of different ways. And one of the easiest ways to get tripped up under the right to know law is for a member of the Zoning Board of Adjustment to innocently send an email to a quorum of the Zoning Board of Adjustment and ask all of the members, hey, what do you think about this pending application, about this variance for this setback, for this chicken coop at this property, at this location? Can we, let me know what your thoughts are. And the email is sent to a quorum of the ZBA, and one or more of the ZBA members start popping off, answering what that member said and asking and providing their input. You have now created an improper, illegal communication, a contemporaneous communication where the members are communicating with each other and discussing public business that should only take place at public meetings. And in fact, there's a statute that deals with, how we're supposed to avoid using sequential communications to avoid the compliance with the right to know law. So I think the key thing to keep in mind is that convening can be more than just being in a room together. It could be convening through a chat session, through an email. It could be convening through a telephone call. So long as you have a quorum of those members present and you're discussing public business, that would be a public meeting, and you'd have to comply with giving the public notice of the meeting and giving them opportunities to attend, which would be impossible if it's an email communication. Yes?
Suppose you're just sending out information that you're going to discuss at the next meeting. You just want to give them that information ahead of time so they can review it.
That's okay, so long as you do the following. Make sure you send that communication by the blind CC method. So if you're the chair and you want to send the email to everybody so that no one can hit reply all, you put all the email address in the BCC section of the email program. That's called the blind CC. So when the person receives it, it looks like it just came from the chairperson to the member. And if I wanted to reply to that email, my email reply would only go back to the chairperson. It would not go to all the other members, because I don't know as a recipient who all the recipients are, because it's a blind CC. So that's the way you avoid the problem. It's not always the problem with the first email, the email that's sent to the quorum of the public body. It's the response. I've now hit reply all and started a discussion electronically with the members of a public body, and that's supposed to be avoided. So, okay, go ahead, send that communication to the members of the public body, but use the blind CC delivery method. Or better yet, if you can have staff send it out for you, that might even be better. So I think I've already indicated what is a quorum. It's always a majority of the membership of a public body. You can't define a quorum as less than a membership or more, greater than. You can define it less than, but you can't define a quorum to be greater than the membership, the majority of the membership of the public body. Although there might be another statute that applies. I don't know how that works under your charter, but there are towns and cities that have charters that might specify that in order to take action on a particular issue, you have to have some kind of a supermajority of that particular body there. That doesn't negate the obligation to still convene as a public meeting when you have a quorum present. And that's always a requirement that has to be fulfilled when you have a quorum of a public body. One of the questions that I have received a lot recently, what if we have less than a membership of the public body present? can't we just go ahead and discuss a few things? I mean, let's think about situations where you had a public meeting scheduled, and it was the public meeting of, let's say, the planning board, and you have a 9-member planning board, but only 3 members of the planning board show up, so you don't have a quorum. But the members who do show up say, well, since we're here, why don't we just go ahead and discuss some of the stuff we were going to discuss anyway? Now, here's the problem with that. You're now, in effect, doing public business. You're having a discussion. I don't even know if you're going to record these minutes. Probably you should, but then that creates an affirmation of the fact that you're now carrying on a discussion that's supposed to only take place when a quorum is present, and you've complied with the right to know law, which you did comply with the right to know law, but theoretically you've now discontinued the meeting or didn't convene the meeting, but you all stayed behind, the 3 members stayed behind and decided to have a discussion. And that's problematic because this particular statute, and I have to read it here, I'm going to have to start having my typeface larger, unless exempted from the right to know law. Oh, my thing got cut off a little bit here on the bottom, but I can tell you what it says. This is an important part of the statute, 91-A, 2-A. I always feel like it's useful to read this part of the statute. What it says is, and this is paragraph 2, communications outside a meeting, including but not limited to sequential communications among members of a public body, shall not be used to circumvent the spirit and purpose of this chapter as expressed in 91-A. And so this is the example that I've given before on that particular issue. Let's assume you've got a 5-member zoning board of adjustment, and I'm member A. I call up member B and I say, hey, you know, we got this, the chicken coop setback requirement. You know, what do you think about that? Now, at that point, we really aren't violating the right to know law. It's just 2 members having discussion. And B says, well, I don't know. Let me see what C says. So B then calls C. Hey, A just called me and talked to me about what happened, what's going on with the setback for the chicken coop. You know, this is what I thought, this is what he said. What do you think? He says, well, I'm not so sure. Why don't I call D and see what D thinks? So pretty soon you now have a series of sequential conversations which are really avoiding the duty to have that very discussion that you're having through these sequential communications by telephone are supposed to be taking at a public meeting. So I think this is the one area where, you know, the better practice is, and this, I just had this question the other day in a community not far from here, where there was a board that was convened, some particular public body was convened, had certain obligations with regards to the construction of a building. And they were, you know, at a public meeting discussing, you know, feedback they were going to give to the proposed contractor. And that was fine, all well and good, they comply with the right to know law. But then 3 members, less than a quorum of that public body, I guess they must have been at lunch someplace at a diner, and they started talking about it. Said, well, let's come up with some more questions, and did so as a process of trying to supplement what was already taking place at a public meeting. And you know, what I did say in that particular instance is that's unwise. You know, that should have been something that the non-quorum convened members of the public body should have said, let's come back in another meeting and supplement our discussion that we had previously. Greatly discourage when you don't have a quorum that night. Don't conduct the meeting. Don't say, let's just stick around and have a discussion. That's just an unwise practice, and I think it's inconsistent with the statute. So public body is another part of the definition, what is a public body? And that's typically pretty easy for members of a public body to understand. A public body is defined by some statute which says this is the planning board, this is the duty of the planning board, this is the ZBA, or by your charter provision you might have a emergency response committee, you might have a highway safety committee, and these might be defined again by your charter. These are various public bodies that have been created by charter or by statute. So it's pretty easy to understand that those are public bodies, and that public body and the majority of the membership would have to comply with giving notice of public meetings, letting the public attend, and keeping minutes. But the other part of the definition is important to keep in mind. This issue comes up occasionally, not too infrequently, where a public body creates an advisory group or an advisory committee. So let's say the Conservation Commission creates a subcommittee called a committee to study its wetlands regulations, and they assigned 2 or 3 members of the Conservation Commission to carry out that task. Well, now that subcommittee is itself a public body, and that subcommittee now has to comply with the duty to give notice to the public, let the public attend, and keep minutes of its meetings. So it extends to anything that's advisory, and typically I would say, you know, anything that was created by another public body. So generally speaking, the planning board has the inherent authority to create advisory committees, as would the zoning board of adjustment, as would be the case for many other public bodies. They can create advisory committees, but those advisory committees are in fact going to be public bodies, and they have to comply with the right to know law. Yes, in the front.
Well, does that apply if that advisory committee is comprised of less than a quorum of members?
Yes, because you've created a new public body. And so what you're gonna, in essence, be in a
Even
position.
an ad hoc committee?
Could be an ad hoc committee. If it's created by a public body. Now, I'm not talking about the citizens out in the city of Laconia creating an ad hoc committee to address downtown blight. Your downtown is beautiful, by the way. And that would be a citizen group. But I'm talking about a public body deliberately creating another advisory group to carry out some part of its function. So, and so you probably have to have some degree of specificity when you do these things. So when I was on the planning board in my town, I was assigned a task that I rue to this day, but I did anyway. I was assigned to be the master plan update subcommittee chair. And actually, I forced someone else to be a co-chair with me, so I didn't have to be the chair of this subcommittee. But we actually had the planning board say, and the subcommittee will comprise of these 3 planning board members, plus, and then we identified various town departments and other boards to be partners and part of the subcommittee. But just for the purpose of completeness, anytime that subcommittee met, we treated it as a public meeting, and we gave notice to the public, and we let the public attend, and we kept minutes. I think generally speaking, what this slide is really meant to convey, you're meeting in ordinary circumstances, so anytime you can convene and the members can communicate with each other contemporaneously, and again, to discuss or act upon matters over which the public body has control, jurisdiction, or advisory power. What I would distinguish, I think this is on the next slide, there are things called not meetings or non-meetings. So there's a series of things that would not be considered meetings. And one of these would be a chance, social, or other encounter not convened for the purpose of discussing or acting upon such matters shall not constitute a meeting if no decisions are made regarding such matters. So what would that reflect? What would that a circumstance likely arise? Well, when I was on the planning board in my town, we had a Christmas party every year at the chairman's office, home. So every Christmas, we had this party during the month of December for all the planning board members. That was a social encounter, not convened for the purpose of acting on planning board business. Now, did we discuss some planning board cases? Probably, but it was just happenstance and nothing in particular. It was really just meant to be a social encounter. One of the others, which I frequently had been asked questions about, what if 3 members of the select board are all in the same car traveling down from Conway to Concord to attend a conference? Is that a meeting? And I said, no, it's not a meeting. You're not there for the purpose of conducting a meeting of the select board of 3 people. You're there for the purpose of using a transportation conveyance to get to a public meeting. So that's not a meeting. So, yes?
If you have a working session of like the Conservation Commission, is that a non-meeting?
No, it's a meeting, because you're discussing matters over which the Conservation Commission has jurisdiction. So anytime you discuss something, whether you discuss something you have jurisdiction over, make a decision about it, that's a public meeting. It is a meeting about which you would have to comply with the right to know law. These are the exception, and again, the statute gives us these phrases, and they don't call them non-meetings, but that's the way we can give you a shorthand for understanding these events, these occurrences, these occasions when their public bodies get together are not considered meetings. The other one, which is which applies here, is collective bargaining. So when the city council gets together to discuss with the city manager the strategy they're going to undertake for future negotiations with some union, that's considered a non-meeting. They don't have to invite the public because they're allowed to have these discussions to develop their union bargaining strategy. So too, when the union representatives meet with the city manager, maybe one or two of the council members, that's also not a meeting. And so that you can have these negotiations on union management matters under collective bargaining without complying with the right to know law. When you consult with your legal counsel, public bodies have the same right to have confidential communications with their lawyer. So if the city lawyer or some outside lawyer doing work for your particular public body or group is meeting with you to give you contemporaneous exchange of information and legal advice, that's considered protected by the right to know law, that the right to know law doesn't apply and the public cannot attend those meetings. And by the way, there's another provision of the right to know law which makes clear that written communications and verbal communications received from a lawyer doing work for the city, town, or a public body is also exempt from disclosure under the right to know law. So there's a protection, a full panoply of protection of the attorney-client privilege. You can circulate draft documents, which is a very, very narrow application of an ability to make a decision at a public meeting about what a draft document will say and allow one member to be told, here are the 5 bullet points we've agreed to in a public meeting that the document must say. Your job is to compose those into good English for the purpose of sending it out to the proposed recipient. And in that very narrow circumstance, the public body can make that delegation and allow the member to go out, write the letter, and send it to everyone, and allow them to say, yep, it looks good, without having to have another meeting to approve it. However, if any member doesn't in any way agree with what was discussed and wants to revise the bullet points, all bets are off. You got to come back and have a public meeting again. So it's a very, very narrow purpose for draft documents. And then, so that really completes these opportunities to have what's considered meetings which are non-meetings, not subject to the right to know law. I think the key thing for most public bodies is the social encounters. So not intended for the purpose of carrying out public business. So the basic requirements, once you've had a quorum of a public body convened for the purposes of acting upon matters over which that public body has jurisdiction or authority or ability to carry out those issues, what are the requirements? Well, there's 3 basic requirements. You have to give public notice to the public of the date, time, and place of the meeting. The meeting has to be open to the public, that is, the public has the right to attend, and then you have to prepare meeting minutes. And the notice requirement is fairly simple. 24-hour notice before the meeting, not including Sundays and legal holidays, posted in 2 public places, one of which can be the municipality's website. That's the basic minimum you have to tell the public of any public meeting. And once you've complied with that, you've met the requirements of the notice requirement under the statute. So this helpful little rubric is intended to give you kind of a thumbnail of that. 24 hours minimum, 2 public places, one of which can be the website. And then there are requirements for emergency notice, which we'll discuss in a minute, but I want to talk about the posting requirements under the statute. So what this, hold on a second. If I can just, no, I can't do that. So one thing I want to mention about the notice requirement that the statute now contains is a provision that gives you information about how you're supposed to let the public know of the public meeting. And if you give me a moment, I can put my finger on it. It says, if a public body chooses to post meeting notices on the body's internet website, it has to do so in a consistent and reasonably accessible location on the website. But this is the key provision. If it does not post notices on the website, it shall post and maintain a notice on the website stating where meeting notices are posted. So what I would tell you that the key thing to keep in mind about this is that most municipalities are posting public meeting notices on your websites. So I think the rule of the road there is that the place where those meeting notices are headlined should be on the landing page of the website in the upper right-hand corner of the website. That's where most people, when they go to a website, the first place they look. And I think the best practice would be at your website, on the landing page, there would be a box. Public meeting notices here. And ideally, someone could just click that and it would take them to a page with a list of all upcoming public meeting notices. So I think that's the better practice. However, you're not required to do that. If you don't post notices on the website, you still have to post a notice on the website saying, all public meeting notices in the town of Bow are posted in this bulletin board out in front of town hall or out in front of the library with the addresses, et cetera. So that's just, you know, the one requirement of giving notice under the right to know law. And I would just also mention here, you might have more restrictive requirements for giving public meeting notices. So for instance, when the planning board, this depends on your local subdivision or site plan regulations, is going to accept a subdivision as a completed application, they have to give notice to the abutters 10 days before the meeting, plus posting the notice in a newspaper in general circulation in the community. And typically, the better practice is the 10 days does not include the date of the posting or the date of the meeting. And you just make sure that's just as a longer time period with more robust forms of notice to various individuals such as abutters, including those who've got their professional seals on the plan or plats. So that just indicates that the right to know law notice requirements, that's the floor, but other statutes may require different forms of notice. One of the other areas where sometimes less special land use boards can be tricked up here is there's a provision now both for planning boards and ZBAs because notice to all the abutters and notice by newspaper, it gets a little expensive. You don't want to repeat those notices if you don't have to. So there's new statutes that allow a planning board and a ZBA, when they can't complete the action on a particular pending matter, they can vote to continue it to another date, time, and place. And if they do that, they don't have to send out a butter notification, a notification by newspaper, but they still have to provide the basic right to know notice. That is, they still have to give notice 24 hours before the meeting that the planning board is meeting on this date, time, and place to continue the hearing on this matter, although they didn't have to re-notify the abutters or send notice out in the newspaper. Now I've done something.
It escaped.
Yes, thank you. There we go. So switching back to in-person meetings, I've mentioned that there was a period of time under emergency order number 12 where you could have totally virtual meetings, and a virtual meeting option went away with the expiration of the state of emergency, which occurred on June 11, 2021. And so since that time, whenever a public body meets, you have to have a quorum of the public body at the physical location. And that's always been the same requirement in the statute. So that's a continuing obligation ever since the expiration of emergency order number 12. As I've said before, nothing prevents public bodies from allowing the public to participate and attend meetings virtually by Zoom or whatever virtual meeting platform municipalities wishes to employ to allow public access. Now, you do have the option, that's why I said there are some virtuality abilities that still remain. So you can still allow a member to participate remotely in a meeting so long as you have that quorum in the physical meeting place. But there are some things you need to be sure that you comply with. Number one, you have to have that quorum present. Number two, all board members obviously have to hear everyone in the room, and the member participating remotely has to be able to hear all of what's being said in the room. So you have to test the microphone system to make sure it's audible to everybody, and his or her voice reporting remotely is also audible. That member has to indicate whether there are any people in the room with them in the remote location, and you also have to be sure that all votes are by roll call vote. And unfortunately, that would include a vote to approve the minutes. So anytime you have, because my ZBA, currently we have one member of our ZBA who, because of particular problems that a family member has with potential exposure to communicable diseases, he just always insists on participating remotely. And every time we have a meeting, we make a motion to allow him to participate remotely because his attendance is not reasonably practical. And then throughout the rest of the meeting, anytime we vote on something, we have to do it by roll call vote. So, but you know, your ability to do this is limited to the fact that you still have to have a quorum. So theoretically, if you have a planning board of 9, you could have you know, a 5-member quorum in the meeting room, and you might have 1 or 2 members participating remotely. And that's permissible so long as you follow these steps that are required for allowing remote participation. Yes?
I got a question for you. So does that mean that you have to physically have a quorum in the room,
Physically have a quorum in the room. You've got to have that physical quorum in the room, yes.
not including the remote person?
Not including the remote person. So, planning board of 7, you've got to have 4 people there. 9, you've got to have 5. My ZBA, we always have to have 3. So, because all ZBAs have 5 members. So, yeah, that is an absolute requirement. There is this other thing called an emergency. So, there is an ability under the statute for the chair to declare an emergency. And you still have to have a physical location of the meeting, but you may no longer have to have a quorum of the public body at the physical location. And you still have to have these issues addressed. Everyone can see and hear what's going on. You have to identify persons in the remote location, and all votes have to be by roll call vote. But this is a very narrow exception. So how can we have an emergency? An emergency, as the statute says, my book is much better. So in order to have an emergency where you don't have a quorum of the public body, a physical location, the statute would say, as I can find it here, an emergency means a situation where immediate, undelayed action is deemed imperative by the chair or presiding officer of the public body, who shall post a notice of the time and place of the meeting as soon as practical. And that's emphasized here in another part of the same statute. And the determination as to whether or not there is an immediate action deemed imperative, and the physical presence of a quorum is not practical under the circumstances, the determination is made while the emergency exists, and it's made by the presiding officer of the public body. But this is a very narrow exception. The only one that I could actually think up, let's imagine a town, many of those in this state, where you've got, you know, a town bisected by a river, and you have an emergency where the only bridge that connects part A of the town to part B of the town has just been washed out by a flood. And there's a 5-member select board. There's 2 of them over here on this side of the river, and there's 3 of them over here on the other side of the river. And the 3 over here on the other side of the river, they're not anywhere near town hall, and they can't get to town hall, and they all can't get together. And there's an immediate need, because we've got to call in FEMA, and FEMA won't come in with the stuff to repair the bridge unless they vote to say, yes, go ahead. So, yeah, and that circumstance, you could say there's immediate undelayed action deemed imperative by the chair of the select board. We're going to call an emergency meeting and not have a quorum in a physical location. So it's extremely rare, and before you do it, talk to your city attorney. I'll probably advise you not to do it, but it may depend on the circumstances. I've already touched on electronic communications a little bit, but I would just emphasize that provision that I've mentioned to you before, 91-A:2-A. Communications outside a meeting, including but not limited to sequential communications amongst a member of a public body, should not be used to circumvent the spirit and purpose of the chapter. So what I just emphasize for public bodies is don't engage in any kind of substantive discussion on matters before you as a public body by email. Just don't do it. If need to share information, that's fine. Send the email out using the blind CC delivery method, so no one can hit reply all. So for instance, on my ZBA, after our meeting, a week or two afterwards, we get a draft set of minutes for us to consider at the next meeting of the ZBA, and the staff person sends it to us by blind CC, and she says, here's the minutes, bring your comments to the meeting, where we can discuss any changes we want and vote on a final approval of the minutes. That's just the better practice. Now, there could be situations where you need some kind of feedback between members of the public body and the chair to make certain decisions. So there could be rare circumstances where there's a snowstorm, like the one that's going to happen Friday night, and there was a meeting of the planning board scheduled, and how does the planning board chair let everyone know that we can't let you into the town hall because, I don't know, the snow removal emergency is so bad we can't get this hall. So you just might need to send an email to everybody directly saying, the meeting is canceled, we're not gonna have a meeting, it's off. You know, let me know a date that you'd be available for a follow-up meeting. And you're just asking for the membership to tell you when they'd be available the following week for a substitute meeting. That's okay, because it's administrative matters. It's not a substantive issue that you're addressing as a member of the planning board. So that's kind of where you have to, you know, confine, I think, generally the use of email. And again, generally, I think it's better if you can, if you have the staff to manage email communications with the membership, just always be sure, you know, it's transmitted via the blind CC method. So reply all, I think, is, if I could remove that button from email communications, would make, I think, the lives of most government attorneys much easier. So the meetings are open to the public, and there's a lot of content that goes into that language open to the public. So let me just go over some of the issues that are important. There's a provision of the right to know law that says at every meeting, the public has a right to, again, I'm gonna go back to my book. Any person, well, number one, except for town meetings, you can't have secret ballots. So at a public meeting, there's no such thing as a secret ballot. And by the way, and I've seen some of you do this, you know, you got your smartphone and you've just sent a text to the member down at the end of the meeting room and say, what do you think about this person's presentation? Do you believe what he or she is saying? Don't do that, because now you're carrying on discussions that the public can't know anything about. So, so you can't have secret ballots. You can't let's vote, by straw, putting votes into a hat. No. Everything has to be above board. By the way, the public, any person is attending your public meeting has a right to use recording devices, including but not limited to tape recorders, cameras, videotape equipment at the meetings. They don't need your permission. They can come into your public meeting, they can set up a video recording machine, they can set up the smartphone on the desk and record everything that's going on, and that's perfectly permissible. I've seen it where somebody will come into a public meeting and they're live streaming the meeting directly onto YouTube, and you can't do anything about it. Or they've taken a recording of your meeting and now they've turned it into a parody of a public meeting and make you look silly on some YouTube channel. You can't do anything about that either. That's unfortunately covered by the First Amendment. So open it includes this concept that there's no secret ballots. The public has a right to see and hear what's going on, and they can record anything that goes on. Now, who is the public? A couple of things I would say about the public. The public is anyone who wants to come to your meeting. And it's not just residents of the city of Laconia. Anyone can attend your public meeting. So the statute doesn't refer to the public as applied to just people who are residing in the city of Laconia. So anyone can come in. I mean, you could even have anyone could come off the street and attend your public meetings. And you couldn't ask for their identification or their ID or where they're from. In the back.
So, under that situation, if the board has, before the meeting, rules that say who can speak at a meeting, i.e. only residents can speak, can you make that rule, and can you, so someone from Concord comes up here, just to be a pain, can you limit them from speaking?
Let me come to that in a second, because right now I'm just talking about attendance. So
Okay.
one of the things I would emphasize is, this part of the right to know law only applies to the ability of people to attend your public meetings. It does not say whether or not they have the right to participate, so we'll touch that in a second.
Sure.
Because there are very specific rules for zoning boards and planning boards as who's allowed to speak. Yes?
Do the meetings have to be ADA accessible?
Well, I think, and are we talking about physically accessible or other forms of accessibility?
ADA, so, I mean, handicapped person has to be able to access the meeting.
Right, but there's a couple of parts of that. There would be, is there accessibility defined by their physical limitation or being able to see and hear? So, because it gets a little trickier about the see and hear part.
I think ADA is physical.
Right, it can also extend, would give you a heads up that there has been an argument advanced in certain states that cities and towns are required to make their websites accessible to the blind and hearing impaired. And that requires certain significant IT investments. But as a general proposition, I agree. The physical location of the meeting has to be accessible to people with physical disabilities. Yes. And, that may require meetings in different rooms, access with elevators, et cetera. So yes, it should be accessible for the physically disabled. Now, are you now required to have someone who is interpreting what's going on with sign language? I haven't quite addressed that issue recently, but I wouldn't be surprised at some point it becomes an issue in certain circumstances. It may depend upon whether or not someone brings to your attention they have a need for sign language assistance or other forms of assistance for understanding what's going on. But as a basic requirement, yes, physical accessibility is a necessity. So let's talk about public comment, which is really what we're talking about.
Actually, I do have a question about that.
What's that?
Can you substitute like some sort of, I don't know, Zoom accessibility to substitute?
Theoretically, would that be a substitute for physical attendance?
Yeah.
That's a really good question. Let's assume there was a city or a municipality that couldn't grant access. I have to tell you, I actually saw this happen one time. I worked for a town that had the planning board meetings in a basement level, and it was a long downstairs into the basement level. It had a staircase elevator contraption that would allow people to get down there, and just so happened someone showed up with the wheelchair, and they couldn't get the thing to work. And they had to stop the meeting. And the fire department had come over and tried to figure out how it worked, and they had to cancel and reschedule the meeting because he couldn't get access. And reasonably, he was entitled to access. So I don't know, at that point, I don't know that we had, that was way before the pandemic. Could the town have said, well, we'll substitute Zoom access? Or maybe access in another room in the same building where there would be comparable access to the meeting in terms of seeing and hearing what's going on. That might suffice. I haven't seen that issue come up yet. So let's talk about public comment. So the public has no right to speak at your public meetings unless you give them that right, or by statute they're allowed to speak at public meetings. So generally speaking, if you're going to allow public comment outside of the normal requirements that you might have, say the planning board's holding a public hearing, or the city council's holding a public hearing and the public has a right to speak, you should establish rules and explain the rules and apply them consistently. And if you do have these rules that touch and concern public comment, then it triggers the First Amendment. And under the First Amendment, the ability to control speech, what people say, is limited to time, place, and manner. So you can control how much time people have to speak. You can generally control the manner of the speech because you might require them to sign up beforehand and speak in the order of the people who signed up. And to some degree, that manner may include admonishing them not to use vulgarities when they're making their public presentations. Although, we found recently that sometimes some of the more vulgar Anglo-Saxon words are used more frequently, and they are somewhat protected by the First Amendment, which is a separate issue. But let's talk about having, the control of a public hearing by statute. So the planning board is required to have, there's a certain list of people who are entitled to be heard at planning board hearings. In fact, what the statute says, it's RSA 676:4, when the planning board holds a public hearing, if you hadn't just watching me thumb my, butters are entitled to be heard, the applicant is entitled to be heard, and those whose professional stamps appear on the plan are entitled to be heard. Those with interest in the outcome are entitled to be heard. So you could have someone who's not an abutter who could show that they're directly affected by the project, because there could be people down the street who could be directly affected. They're entitled to be heard. And then the planning board, to some degree, has the discretion to allow others to speak. So let's assume you have that rabble from Concord is coming up here to complain about some activity that the planning board is engaged with. I think there is some degree of control the planning board chair can exercise, given time, place, and manner, how many people are speaking, how much time is allocated for that particular hearing, and reasonably allowing some presentation by one or more of those people, the rabble rousers from Concord. I would not recommend the planning board simply say, we're not going to take testimony from anyone other than abutters, applicants, those who are affected. I think there's language in the statute, which this is RSA 76:4, which would be reasonably interpreted to say the planning board should exercise reasonably its discretion to hear from others, which I would not include just cutting everyone else off. And there's similar language for the Zoning Board of Adjustment. You're really supposed to hear from abutters, the applicant, those who are directly affected, and anyone else who has something reasonable to say. Now, I'm sure there are projects, those of you in the room, or applications or hearings where you've had endless presentations time after time after time, over and over and over again. That's where time, place, and manner comes in. So one of the things I think is an effective way to deal with many people saying the same thing is to state, which there's case law in this, repetitive speech is disruptive speech. So if every person after a certain point gets up and says the same thing, and it's time after time, and after the fourth or fifth person it's just a repeat of the same statement on the same subject, the chair could step in and say, okay, we've heard the same thing from 5 people. The next person, if you don't have something new to add, I'm going to accept that additional testimony because it's disruptive. It's preventing the public body from getting the business of the public meeting done because you're filibustering the process, preventing it from going on. So I think in general, you should think about developing public hearing rules that address these issues. That we have time, place, and manner rules. You've got to sign up beforehand. We're going to limit public presentations no longer 3 or 5 minutes. It has to be a presentation which is germane to the subject at hand. We're going to start with abutters, those who are of direct interest, and then we'll hear from others to the extent time is available, and that if we hear repeated statements of a similar nature, we'll deem some of those statements to be repetitive, and repetitive speech is going to be deemed disruptive speech. So a set of simple rules like that would enable you to effectively deal with a room full of people and still get the hearing done and allow, reasonable opportunity for people to participate. But I think that the bottom line is, just because someone is not a resident of Laconia does not mean they don't have the right to be heard. Because you've invited a public hearing, I don't think you can limit it to just members of the public who reside in the city of Laconia. But yes, go ahead.
You can't require an attendance sheet?
Say that again?
You can't require an attendance sheet?
I think, excuse me, it is reasonable to make sure that the people who speak identify who they are, and to do that as an attendance sheet, that's also reasonable. Like, for instance, I asked everyone coming here today to identify themselves. I think you would do the same thing. You would have a speaker list. So for the public hearing on this particular application, we've got a list of those who want to participate. Please indicate your name and any affiliation you wish to
Address?
offer to us.
Address?
You could, well, address, let me just give you a story. So when I was on representing a planning board in southern New Hampshire, luckily, this was something done by the person who was taking the minutes. He made sure that everyone's address was recorded, so if they spoke. And it became material that one of the people who spoke was in a building that was in a butter to the premises under consideration. And the judge in particular said, oh, well, this person said, I'm worried about, it was a McDonald's with the outdoor speaker blaring at night, 2 burgers for, and they didn't want to have that noise interrupting their daily lives, especially late at night. And so the court took note of the fact that that address was in the record. So it is a good idea to get the person's address because it could be material to the information at hand, although you may have to be cautious. There are people who have protective orders where they're only required to disclose their mailing address as the Attorney General's office. So you,
I think I'm more interested in city. In other words, we get somebody comes into the planning board that lives up in Colebrook. It starts raising hell about something down here. It'd be nice to know.
I think that's reasonable. I think that's reasonable to ask their address, and that would help you address, give weight or to minimize the weight of that particular testimony. I think that's reasonable. Just be prepared to, there may be some people, it's rare, but I've seen it before, who have, protective orders who they are reluctant to give out their addresses in the back.
So then you are allowed to ask them, how are you affected by this project in that case?
Well, yes, I think that's reasonable. Is you could, if you were going to ask that question, I don't know how that's going to play itself out, but if someone has signed up and they're going to speak, do you ask before they start to speak, what's your interest in the outcome? I'm not sure I would do that.
I was thinking of right in the middle of their ranting and raving.
Well, you could, again, they're going to get 2 to 3 minutes. You're going to limit their time. If someone's going to keep track, they've got 2 or 3 minutes to speak. Maybe it's 5 minutes, whatever you feel comfortable with. Now, generally speaking at public hearing, when I'm on the ZBA, when the public is speaking, the chair will say, does any member have a question for this person? So I think that's what I would do as the chair, say, does anyone have a question for this person? I wouldn't necessarily automatically have the chair to say, well, what's your interest in this case? That's just my approach. Yes, right here.
Public comment, though, can't be construed as the right to a public question. In other words,
I agree.
a chair or a member doesn't, or shouldn't perhaps, actually respond to random questions from the audience. I mean, I would think it would be the chairman's discretion whether to allow that question to be addressed from the floor.
I would agree with that in terms of having it addressed. I think what the chair would do, and this is certainly the case at my town meeting, if there's a question which the moderator thinks should be answered by the proponent of that particular warrant article or by the applicant's engineer, you would say, Mr. Engineer, this is a good question. Why don't you answer that question for the room as a whole? But I think that's the chair's discretion, whether you're going to have questions answered from at that particular moment. Yes?
As the chair, would you also have the ability to write the question down and then at the end of the public hearing portion, ask that to the different people that it would pertain to?
You could certainly do it that way. I think I suppose if that's the approach you take as the chair to record those questions and then, point at various parties in the room who could answer those questions. You could do that after the public testimony has been completed. I think if you're going to take that approach, you should say, I as the chair, I'm going to take your statements. If you have particular questions, I'm going to note them and then have either the applicant's engineer or the applicant themselves answer those questions when we completed the public comment and hearing portion. Yes, you can do that. I think, you know, a good idea to lay that out for people in the room or put it in your rules of procedure. Yeah.
As a follow-up, if I may, in providing direction to the public for their public discussion of the issue at hand, they're instructed to ask their question of the board and not the audience, because I'm the chair of the ZBA, and I've asked them not to do questions to the audience, and that the audience does not intercede into what the speaker is saying. Is that appropriate?
Absolutely, and that's precisely what my moderator does at my town meeting. The moderator makes clear, questions that come from the floor are directed to the moderator, not from the person speaking to some other, whether it's somebody else at the head table or somebody else in the room. The moderator will then, you know, either treat the question as which one's appropriate, and the moderator say, I'm sorry, sir, I'm going to treat that question as merely rhetorical and argumentative and not one that I'm going to seek out an answer to. On the other hand, the moderator can say, that's a good question. Let's see if we can get the city attorney or the finance director to answer that question. Yes, that is the much better way to avoid the back and forth that can take place at public meetings. So I agree with that. Yes.
If we have an item on the agenda that's not public hearing, but there's members of the public that are available that want to speak, can we open that to the public for comment? Or do we have to keep that as not open for public comment?
Well, I guess I would say this, you know, if you're going to have a public, first, number one, if it is the case that you're repeatedly having occasions where something on the agenda that was not set for public hearing, members of the public want to speak to those issues, maybe it's a good idea to then set aside in your rules of procedure or in your agenda that we're going to have an open public comment period at this point of the meeting, so that members of the public who are here, who want to discuss something that's not on the public hearing agenda, but is on the agenda, they want to discuss something that's on the agenda, we'll give you that opportunity. You can do that. Otherwise, the problem that I foresee, that I've seen before in public bodies, and you know, it's a little bit of, you know, how you just interact with the people you're familiar with. You know, if you've got 5 people in the room who are attending the meeting, and you consistently allow this one person, which everyone knows and appreciates their contributions to the community, to speak or give public comment on anything they want to, where others who are not maybe familiar to everyone in town or new to town, they hardly get called upon to make a comment, even though that's not a public comment period. It's going to look like you're really favoring some people over others. So consistency in terms of public comment rules is probably the better way to approach it. So rather than try to individually decide a certain person is a worthy person to hear from, probably better to say we're going to have an open public comment period at some point during the agenda, and anyone could come in and speak on something that's on the agenda that wasn't scheduled for a public hearing. I think that would be the better practice. Yes?
So in a case like you were just describing, where a person keeps commenting and preventing other people from commenting, I'm not sure about this, but under Robert's Rules of Order, can't you specify that everybody gets to comment, and then we'll go back and people can make a second comment?
Absolutely. I'm glad you bring that up. That would certainly be one of the things I would put in my rules of procedure for public comment, that everyone has to sign up to speak. Everyone gets, let's say, 3 minutes. They'll speak in the order in which they've signed up, and that no person can speak a second time until everyone has had one chance to speak. And I know that that's what my town moderator does at our public meetings. And that certainly minimizes one person, you know, dominating the flow of information. But again, I think that you can also say that the person who's repeatedly saying the same thing, after a while, that's repetitive speech, and repetitive speech is considered disruptive speech. Again, I can't read my damn thing here. Okay, So about public comment, you should definitely have rules of procedure. So the First Amendment can apply, so that means under our First Amendment, we have very, one of the things that I've learned, certainly since being with the New Hampshire Municipal Association, the rules set down by the federal courts and the Supreme Court on the First Amendment, it's just amazing how ornate and detailed they are. And you'd think they're kind of annoying, but I gotta tell you, there's one thing that is just glorious about this country is the absolute devotion by our judiciary to protect the rights of the public to speak. It's really a remarkable thing. And you see that through the decisions of the Supreme Court. And that's why they talk about time, place, and manner, that you can control the time, place, and manner, but you can't control the content of what people are gonna say. To some degree, you can. Like, you could put in your public comment rules that we're gonna take public comment on things on the agenda. But if you don't have something to speak to on the agenda, you have to ask us beforehand whether you can speak on that. And we'll try to make an arrangement either at this meeting or another meeting where you'll be able to offer your comment on that issue. Maybe you want to talk about the rain in Spain falling mainly on the plain, but that's fine. It's not something that the planning board really deals with. Whether or not we'd ever give you a chance to do so is a separate issue.
Flood control ordinance.
What's that?
Flood control ordinance.
Flood control ordinance. For instance, one of the areas which we've seen a lot come up there are some, I've seen these in public comment rules where we're only going to take positive comments and we're gonna prohibit comments, negative comments about municipal employees. That just won't fly. One of the things with regards to public service, you're gonna have to put up with a little bit of negative comment from members of the public. The other thing I would just say, the last bullet here, if a person is not complying with the public comment rules and they've been warned probably about 3 times that you're out of bounds, they can be removed and they can be arrested for disturbing the peace. And there's very clear case law on that subject. In fact, there's a case in New Hampshire, Dominic, State versus Dominic, where a member of the select board, and I can't remember what town it was attending a select board meeting, and the chair of the select board was managing the meeting, and that member kept butting in the middle of presentations by others, whether that he wanted to be heard, his point of view had to be heard. And he kept doing it. He did it a second time, and he finally did it a third time. And the chair said, look, I have not recognized you. I will recognize you, but you're not going to be taken out of order. Please desist. And when he kept speaking, when he wasn't recognized, the chair asked the police chief to arrest him for disturbing the peace, and it was considered disturbing the peace, and he was convicted, and it went to the New Hampshire Supreme Court, and the Supreme Court said, yes, that's one of the most important cardinal rules of public bodies, is they ultimately have the ability to say, you're out of order, and if you persist, you're going to be arrested for disturbing the peace, because interrupting public business is considered disturbing the peace. And so that is one authority which is to be used very, very sparingly by a public body member, but when it's necessary, it may be required to have the assistance of a constable to arrest someone. I would just say, if it came to that, let's say you had a really hot topic that was really hard to control and people were really exercised, and there was an issue that perhaps related to the need to have someone removed for disturbing the peace, the officer has to be in the room, and the officer has to see that you've given the person at least 3 opportunities to abide by the public meeting rules, because the officer has to have probable cause to arrest the person for disturbing the peace. And the officer can't get that probable cause until the officer sees it happen in their presence. It's not enough for the officer to be called and said, this person just did this 5 minutes ago. That won't work because the officer won't have probable cause. And officers can only conduct an arrest with probable cause. So, but again, I hope that's never necessary for your public bodies, but it is one of the rules that are available to public bodies to control the management of public meetings. There, I did it again, I think. Now, the other thing that I would just say, part of the public meeting process is the public has a right to notice, and the public has a right to attend, don't necessarily have a right to speak, depending upon your public meeting rules and a statute that applies. But then you're also required to create meeting minutes. So within 5 business days of every meeting, you have to create minutes. And there's basic content that's really not that hard to comply with. So you have to have the names of the members present, the persons appearing before the public body. That's not everybody in the room. That's anyone who spoke, and you want to make sure you get their name, and getting their address is a good idea, so that's recorded in the minutes. You have to have a description of the subject matter discussed. You have to have all final decisions made, and you have to state the names of the members who made or seconded each motion. So those are the minimum requirements, and those minutes must be prepared, at least in draft form, within 5 business days. Now, you're not going to reconvene as a public meeting, public body, and approve those minutes within 5 business days. It's just not going to happen. You'd have too many meetings. But the law does require these minutes to be prepared. So either the secretary of the public body or the staff, whoever is assisting you, has to compose those minutes. They have to be available for the public to inspect. But you're not required to post unapproved meeting minutes. There is a statute that governs posting meeting minutes, but that only says if a public body maintains an internet website or contracts with a third-party website to maintain the location of where you publish public meetings, public meeting minutes, you're required to only post approved public meeting minutes. You're not required to post draft minutes. So I think that there's some reluctance for public body members to allow the public to look at meeting minutes until they're approved. The reality is that's out of your hands. The meeting minutes are going to have to be somewhere here at City Hall where people can look at them within 5 business days of the meeting. But you can mark them as draft until approved, so that's clear that they're potentially subject to correction or reflection of actual changes. Excuse me. So that is the minimum requirement of public meeting minutes.
Now, the bullet made available, so we don't have the luxury of a secretary here at City Hall. We have a secretary who has a full-time job. If somebody asked for meetings, she could email a draft version, or does that mean that she always has to, within 5 days, email it to the person who's gonna post it on the website?
No, I think it would suffice if she just made it available to someone who asks for access, but you don't have to post it on the website. So all you have to do is make sure there's some ability to have access by the public
Yeah,
to those draft minutes within 5 business days.
yeah, okay.
That's the minimum required.
I have a question.
Yes.
Regarding, we had a lengthy discussion about this before the meeting, and it's posting draft minutes where? Available to the public. So could you put them on a bulletin board downstairs?
Well, the statute just says they have to be available. It doesn't say how they have to be available. They have to be available. That is generally with regards to public records. This is considered a public record. The public has to be able to access that record at the business office of the municipality. So in some fashion, if I'm a member of the public and I went to the ZBA meeting 6 days ago and I want to go see the draft minutes, I should be able to come to somewhere in City Hall, whether it's Community Development Department or somewhere else, you know, where are the draft meeting minutes of the ZBA held 6 days ago. So that's just the minimum requirement, but you're not required to then turn that into something you post on the website. You're only required to post approved minutes on the website. So I'm not here to prescribe how you make them available. Now, that availability may be, as the gentleman suggested here, someone called the Community Development Department and they wanted the minutes of the ZBA meeting 6 days ago. And someone at the Community Development Department gets a message and say, well, okay, I have those draft minutes on the website, I can send them to that person. You could do that. You just say, if the person wants to look at them, I will print them out and put them on the counter. Availability could be achieved in either of those two ways. Yes?
Question for you. Can the draft minutes be sent through email to the board members to peruse to make sure that they're correct before they're sent in to the, say, City Hall?
That's fine, but the board members don't have an unlimited period of time to peruse them before.
Within the 5?
With that, you could do that, yeah, but I think you're asking board members to have a lot more input and time, maybe than they're prepared to devote to that. I think, generally speaking, I think the better practice is to develop a level of comfort with the person who's taking those draft minutes, that they've been able to reasonably do a good job without the need for the members to intervene and tell the person how the draft minutes should be worded. Because now you're in the position of trying to edit, and you're going to have ultimately probably substantive discussions which should only take place at a public meeting. So I'm just not sure it's feasible to have the members participate in editing draft minutes within that 5-day time period. I think it's prone to turning into an improper meeting, and I would not advocate that approach. I think that problematic. Yes?
So the Conservation Commission meetings are recorded, just like this is being recorded.
Right.
And they're put on YouTube. Does that constitute minutes of the meeting?
No. So the statute does not contemplate a recording of that type as the minutes. Actually, the statute, if you really want me to get into the weeds here, I will. But there is this other provision of the statute. It's 91-A:4, and this one could be a little hair-raising. So hold your seats. I know that not everything I say here is going to really be that hair-raising, but so it's 91-A:4 Roman 2, and this is what it says: after the completion of a meeting of a public body, every citizen during the regular or business hours of such public body and on the regular business premises of such public body has the right to inspect all notes, materials, tapes, or other sources used for compiling the minutes of such meetings, and to make memoranda or abstracts, or to copy such notes, materials, tapes, or sources inspected, except as otherwise exempt under 91-A:5. So theoretically, this is how it's supposed to work. The staff person took all these notes, and maybe slips of paper handed in by public body members, and maybe they have an audio tape, maybe there's a Zoom tape, and all of that stuff is going to be brought together by the minute taker to compose the draft minutes. While the minute taker is doing that within that 5 business days, John Q. Public says, oh, I want to see the notes that you took. I want to see that scrap of paper that was handed to you by the member who made the motion. They would have to be made available. So just think now, imagine that you have that obligation. Now you have members of the public body who are also trying to provide guidance to the minute taker on what the minutes should take within that 5 business days. There's a lot going on within that 5 business days. Let's put it that way. And I think that's why you really want to develop that level of comfort with that person, let them do their job, prepare them, and recognize they're not meant to be perfect and they're not the final product. Yes?
Once the minutes are approved, all those draft notes and all that.
Get rid of it all. You can get all rid of all that stuff. In fact, there's a portion of the statute on retention of records that actually refers to the fact that if you used an audio tape to compose the minutes, that audio tape may be disposed of and does not need to be retained as a governmental record once the minutes are approved. But it's within that 5 days that that the statute really is meant to give the greatest possible access to all the stuff that is coming together to make the minutes. So, yeah, that can be a little hair-raising, that particular paragraph. By the way, there's a note here, if the software used to conduct a remote meeting allows for recording, you know, that can be aid of the assistance of the note taker, but it's not a substitute for preparing minutes. So, we're going to move on to non-public sessions. Most public bodies probably will not have a lot of occasion to conduct a non-public session. It would be a rare occasion. The most common one that I think most public bodies might have a non-public session is when the city attorney or an outside counsel is going to meet with you. And you're going to have actually a non-meeting. It's not considered a non-public session. So, but there are some cardinal rules which we always want to emphasize. It's a non-public session, not a non-public meeting. That is, a non-public session always takes place within a meeting. You have to have a regularly convened public meeting with the public given notice, and they're in attendance, and they can take notes of what's going on. And then during that meeting, the public body votes to go into non-public session. And they convene that session, but it's still part of a public meeting. You've done that as part of the public meeting process. And it's different than a non-meeting. So these other things that I talked about, consultation with legal counsel, collective bargaining, social encounters, those are considered non-meetings. This is considered a non-public session. A non-public session is the exception, not the rule. So generally speaking, you're allowed to have, that is, a non-public session is permitted, but it's never required. It is always within the discretion of the public body whether you wish to enter into non-public session. Now, the most commonly reasons why public bodies go into non-public session is probably the ones involving public employees, that is a specific public employee, the hiring of a public employee, the reputation of a person whose reputation might be harmed by a discussion in public, when you're discussing the acquisition of real or personal property where what the city is willing to pay or is willing to sell public property is a material issue that you don't want to disclose to the public. You want to maximize the fiscal resources of the city. There are certain lawsuits. You have a pending case that is brought against the city or being brought by the city. Those lawsuits can take place in non-public session. Emergency preparation within a certain degree. Discussing legal advice. This is one that's important for public bodies these days. Let's say you got, or let's say the chair of the public body got an email from the city attorney or from outside counsel, and you want to discuss the advice received, but the attorney can't be present. You can now go into non-public session to discuss legal advice received from counsel, whether in writing or orally. So let's say the city attorney called the chair of the ZBA and said, this is the advice I'm giving you, share it with the board. You can go into non-public session to discuss that advice. So these are the most common ones. They're not the only ones that are available as non-public sessions. But I do want to mention just a few issues which happen time and time again. And the first one is you go into the non-public session to discuss the dismissal, promotion, compensation, discipline, investigation of charges against a public employee. First thing to recognize about the statute, the way it's worded, it has to be about a particular public employee. So for instance, let's say you want to go into non-public session and discuss all of the salaries of the employees of a particular department, whether they should go up or they should go down. You can't do that in non-public session because to discuss someone's compensation has to be about an individual, not about a collective group of public employees. The other thing about the statute, it refers to a situation where the public employee has a right to a meeting and request that the meeting be open, in which case the request will be granted. That particular phrase has very, very unique meaning. So what it typically requires, if the discussion is going to be about a member of a department or an individual employed by a particular department, that person can insist that the meeting be open if there's a personnel rule for the city of Laconia that says a discussion of someone potential disciplinary action, that person has a right to a public meeting on that subject. But that would have to be in your personnel rules. Or so, for instance, by statute, a police officer who's going to be fired has a right to a public hearing by statute. And that might be different in this city because you might have collective bargaining rules. Or for instance, there's a statutory protection for library employees. You can't fire a library employee without giving them an opportunity for a public hearing. But unless there's a statute or a personnel rule, a person who's going to have a discussion about their compensation, well, not their compensation, typically it's going to be the discipline of the person or investigation of charges against the person or potential discharge, they're not entitled to a public hearing under this provision of the statute, only if they have some right to it by statute or otherwise. The other one, which happens a lot, and I think it's useful to discuss, matters which, if discussed in public, would likely adversely affect the reputation of any person other than a member of the public body itself. That requires, first of all, the person's reputation that is to be injured cannot be a member of the public body. So if we're going to discuss whether or not Steve Buckley should recuse himself from a matter because he's a terrible member, we don't want to have him on this particular contentious ZBA decision, I can't, as a member of the ZBA, say, well, I want to have this in public. You can't discuss this without me being present, and I want to have the public here. And first of all, I can't even have that discussion because I'm a member of the ZBA. I can't complain about my injury being, my reputation being harmed by a discussion. But I think the other thing about harm to reputation, where a public body wants to go into non-public session, it has to be a material harm, not that I'm a Democrat in a totally Republican town. That's immaterial. It has to be something material, something that would lower my status and standing in the community. And so, I know that this is not an uncommon request that I want to discuss this particular issue in non-public, but unless it affects my standing in the community, or as the statute refers to, and this is more common for city councils and select board members, when they're discussing someone's request for an abatement or an exemption for tax purposes because of their inability to pay or poverty, that would injure their standing in the community, having to disclose their financial circumstances if they're adverse ones. And that would be a justification of going to non-public session due to injury to reputation. So to go into non-public session, you have to have a motion to go into non-public session. The motion has to state on its face the basis for the non-public session. Madam Chair, I wish to go into non-public session to discuss the advice I received from town council today pursuant to our 91-A:3, small letter L. And then there has to be a roll call vote, and as long as there's a majority vote in favor of going to non-public, we can then convene in non-public session. You do have to keep minutes in non-public session, and the minutes have to reflect all of the actions taken so that each vote of each member is ascertained and recorded, which kind of sounds like, with the statute is worded, you almost have to take roll call votes and record those roll call votes in non-public session, which is important to emphasize. You can make decisions in non-public session. That's permissible, so long as it's within the subject matter of the reason why you're in non-public session. So you're in non-public session to discuss pending litigation, and you're voting on whether or not to approve the proposed settlement of the case with the city attorney. You can vote, to take that decision, and you can make that vote in non-public session. The couple of things that are useful to keep in mind, as I've already indicated, you can make make decisions in non-public session. There's this other provision now, which is kind of unique, but I guess it was warranted for certain people who've seen things take place in non-public session they disagreed with. So there's this new provision. It's a 91-A:2-A. So if a member of a public body is in a non-public session, and he or she decides that the discussion is going awry, it's going off topic, it's not consistent with the reasons why you're in non-public session, the member can then say, I object to this discussion. I think it's inconsistent with the statute, and I want my objection noted in the record. And then, rather than that member having to leave and avoid having some kind of remedial penalty imposed by a Superior Court judge, they can stay and remain in the public body doing its non-public session, and they would not be absolved. They would not be subject to any penalty for doing so. That is, they can remain because they voiced their objection and stated what they believe to be is incorrect to what the public body is doing. So it's a kind of unique little provision that allows an objector to point out there's an error in how that particular public body is handling a public, a non-public session. And then once the vote, the public body has completed the non-public session, it really is the better practice to return to public session. And there's a reason why you want to return to public session, because generally speaking, you really want to think about going into public session to allow you to have a decision, a deliberate decision on sealing the minutes. So when minutes of public bodies in non-public session have to be disclosed in 72 hours, unless by a 2/3 vote, which is really what you should do after you've completed that non-public session. You should come out of non-public session and vote. Are you going to seal the minutes or keep from public disclosure those minutes? And there are 3 basic reasons why you might vote to keep them exempt from disclosure. Number 1, disclosure would have an adverse effect on someone's reputation. Number 2, the disclosure would render proposed action ineffective. That's the more common one. So if you just had a discussion of whether to settle a pending land use case, you may not want that information known to the public at large until the deal has been sealed with opposing counsel. So it might render the proposed action ineffective. Or number 3, the discussion in non-public pertain to trying to thwart terrorism. So the better practice is right after the conclusion of the non-public session, vote to deal with whether you want to seal the minutes. And I just had a discussion with someone in the public body where, they just up and left after the non-public session, didn't vote on whether to seal the minutes, and 72 hours later, guess what? Someone asked for a copy of those minutes. They were entitled to them because they did not vote to seal them. Turns out it wasn't that important a matter, it was okay to release them, but it's kind of a decision, depending on the circumstance, you want to make right then at that time. Yes?
Okay, so I work with the Board of Assessors. The disclosure for adverse effect on a reputation, and our board members go into non-public session for that. They make their decision out of non-public session, and our minutes typically reflect that the applicant's request was either granted or denied and doesn't go into detail. Is that the appropriate way to report that in the minutes, or?
Let's back up. So you go into non-public session for what?
So for someone who's requested a hardship abatement.
Okay, they've requested an abatement based on inability to pay.
Yeah.
So you're in non-public, and the board does what in non-public?
Typically, they discuss the situation when they come out of non-public session and back into the public meeting.
Right.
They will make a motion to grant or deny the request of the applicant.
Okay.
But they don't go into
Detail.
about what that request was.
Right.
And that's typically how we reflect it in the minutes.
That's okay.
Okay.
You can do it that way. I don't know why they don't vote in non-public session, but they don't have to vote in non-public session whether to grant or deny. But I think they should, in their non-public meeting minutes, reflect their discussion in general terms and keep those discussions non-public.
And then they should seal those?
And they should seal those.
And can they be sealed indefinitely, or do they have?
Nothing can be sealed indefinitely, because the way the statute is worded, I love the wording in this too. What it says is, in the event of such circumstances, so I've listed the 3 circumstances, we got reputation, we've got render proposed action ineffective or pertains to terrorism. The statute says, in the event of such circumstances, information may be withheld until, in the opinion of a majority of the members, the aforesaid circumstances no longer apply. Okay? So what that means is, it's only a provisional sealing. And, I think, and there's some legislation pending on this, there's kind of an expectation that the membership would revisit at some point in the future the basis for sealing those minutes and would vote perhaps to unseal those minutes. However, when you're dealing with reputation of that type, serious harm to reputation based upon inability to pay, I think the taint of that injury to that one's reputation may never be dissipated. So you may always want to keep those minutes non-public. As to be contrasted with, there was a change to the statute not too long ago, where the city went into non-public session because the city was about to acquire a piece of property, and the city did not want to disclose to everybody in the world what the city's prepared to pay. The city has $100,000, but they want to offer 50 at first to see if they can, get a cheaper price. So that's a totally legitimate non-public session. But there now is a provision that says, however, once you've concluded the transaction and you no longer have jeopardy of disclosing to the public at large what you're prepared to pay or what you can pay, you have to disclose that. So once the transaction is closed, or the city is no longer going to pursue the purchase, the non-public meeting minutes must be made available. And that makes sense because there's no reason to keep it non-public. But I think it's harder to say that the minutes would be kept permanently. It's easier to say the minutes may more easily be kept permanently not subject to disclosure when you're dealing with reputation. So again, in your situation, I think the substantive discussion reflected in the minutes about why you thought that person was meritoriously entitled to the tax exemption based on inability to pay, that is the non-public meeting minutes, but you've already in public that you're going to grant or deny the request. And that's going to be in the public meeting minutes. Yes?
So if it was a real estate deal and you wanted to seal the minutes, can you at that same time say seal the minutes to a time certain or till an action is acquired or completed, and then it just self-unseals itself so that you don't have to go back to visit it?
That's a great question. There is language, they added this language. What it certainly says is the following. Minutes related to a discussion held in non-public under subparagraph Roman 2D, acquisition of real or personal property, shall be made available to the public as soon as practicable after the transaction is closed or the public body has decided not to proceed with the transaction. So I would say, I would just implement that paragraph. The problem with, I'm just not comfortable saying they should have an automatic triggering event. I'm not sure that's the better approach. Yes, it would minimize perhaps the board having to go back to relook at things, but I think there's a law that might be making you do that anyway in the near future. I just want to back up because I missed this part. You have no requirement to post an agenda or required to have an agenda or to say that on your agenda you're going to have a non-public session. But I think the better practice is for every agenda the public body has, because you never know what might come up as a need for a non-public session. I would have the following on every agenda. This public body may enter into one or more non-public sessions as permitted under 91-A:3. Very simple. Now you might list you're going to have non-public sessions. You might even list the subject matters you're going to have in non-public session. But just in the event you're not sure, having that on your agenda is probably a safeguard against someone saying, you didn't tell me you were going to have a non-public session. Legally, it's not, there's no limit on who could attend a non-public session, but generally speaking, those who attend non-public sessions should be limited to the public body itself. And such other officials or employees who are necessary to that discussion. So for the, excuse me, the assessor, you might need the chief assessor. You might need, I don't know, somebody from engineering or, who knows, any number of things that might be material to an assessing discussion. So, but generally speaking, you want to contract the number of people to those who are absolutely necessary. Talked about a disclosure seal. You are now required under HB 108 to maintain a list of non-public meeting minutes. So as of January 1st, 2022, every public body has to have a list. Now this is prospective only. This is not dealing with meeting minutes prior to January 1st, 2022. So anytime you've held meeting, non-public meeting minutes after January 1st, 2022 and continuing, you have to have a list that identifies the public body, states the date and time of the non-public session, states the exemption for the non-public session, states the date of the decision to seal the minutes, and states the date of any subsequent decision to unseal the minutes. So it's a lot of bookkeeping that you're supposed to have, and it'd be a lot easier, I suppose, if staff could prepare one spreadsheet for each public body so you can track of these things. But it is a necessity so that people can come to City Hall and say, I want to see the non-public meeting minute tracking list for the Board of Assessors or for the ZBA. And it will need to make that available. So that's it. And let's see.
Can I ask one
It's only 7:40. That's not too bad. Didn't keep you too long. Yes, go ahead.
Yeah, I have one more question.
Sure.
The other staff members was asking. If you unseal minutes during a later meeting, do they have to be posted as part of the record with that regular meeting minutes? And if it is deemed that they are to stay sealed, okay, I answered that already.
You can go into non-public session to discuss the unsealing of minutes if the discussion is going to potentially reveal what was in the minutes that you kept sealed. So you just return to non-public session to have the discussion about unsealing the minutes.
Yeah, and then do those, if you unseal them, do those become part of that public record? That meeting minutes?
They become they're part of the record of that public meeting, correct. So they would be added to the record of that particular public meeting, however you store it, correct.
Details and everything that was in.
Whatever you've decided to make available,
Okay,
I'm not gonna prejudge what, if the board has looked at what were the minutes we sealed, and if they voted to unseal them, well, okay, there you go.
Okay.
I mean, is it possible there could be some privacy disclosures that you have to be concerned with? I suppose, but I'm not prejudging whether whether it's appropriate to unseal any particular set of minutes. I think it's up to the public body itself. Okay, so that concludes my presentation. I've handed you the handout. Hopefully that's of assistance. I would just say on the last slide, everyone here, you should know that the legal advisory service at NHMA, what I do 60% of the time is I'm at the office answering your questions by email or by telephone call. So you can contact us and ask questions. Certainly, you may want to turn to the city attorney or the attorneys advising the city, but we are available to provide legal guidance to our members 7 days a week, 5 days a week from 8:30 to 4:30. So thank you for having us here to Laconia, and have a good evening. Thank you. Sure.